Do you know that the law of inheritance is different for movable and immovable properties? Hi, my name is Damini and welcome to Vakilsearch's Real Estate Investment Series. In this episode, we will be discussing how the law of inheritance is different for movable and immovable properties. Let's first understand what are movable and immovable properties. Immovable properties are those that are permanently fixed to the ground. For example, land, buildings, and anything that is rooted to the ground are called immovable properties. Whereas, movable properties is something that you can own and take with you. For example, bank accounts, deposits, demat securities, vehicles, jewellery, growing timber are all called movable properties. When a person passes away without writing a will, his movable and immovable properties are devolved upon his legal heirs as per the law of inheritance. Irrespective of whether there is a will or not, the first step to claim the property, be it movable or immovable, is to obtain a legal heir certificate. This is also called as family member certificate or surviving member certificate in a few states. This certificate is issued by the local revenue officials, which will list out the legal heirs of the deceased person. In this episode, we will discuss what happens to the properties of a person who did not write his will. Once the legal heir certificate is obtained from the local municipals, you have to move before the court for obtaining a succession certificate in case of movable properties and a letter of administration in case of immovable properties. Let's get into a little more detail. How and when to obtain a letter of administration. The letter of administration authorizes the legal heirs to be the administrator of the assets of the deceased person. By using the letter, the legal heirs can register the property of the deceased in their name. If the legal heirs want to sell the property of the deceased without obtaining the letter of administration, they can do so by just having the legal heir certificate. When the immovable property is being sold, all the legal heirs mentioned in the legal heir certificate can sign the conveyance document and can dispose of the property. How and when to obtain a succession certificate? A succession certificate, on the other hand, is also issued by the court, but to claim the movable assets like bank deposits, demat securities, insurance claims, etc. If the value of the asset is more than 5 lakh and there is no nominee appointed to the account, almost all financial institutions which are holding the assets will insist on having the succession certificate. Other movable properties like jewels, vehicles, and other articles can be divided among the legal heirs with their mutual agreement. If the deceased had written a will before his death, then the legal heirs will have to go before the probate court and not before the letter of administration or the succession certificate courts. We can discuss more about probate in the coming episodes of this series. Please follow Vakilsearch's YouTube channel for more updates on real estate investment series, and please reach out to us at www.vakilsearch.com or call us at 7200 365 365. Stay tuned.